All right, we're going to get started. You've been handed some information that Delaney Shea, one of our TAs, has gathered for you that just may be helpful dealing with responses to common objections and various other sort of suggested techniques to use for various aspects of the trial process. As with everything else, do what I say. Take it with somewhat of a grain of salt, not literally. These are just, suggested ways to handle things. And just know that there's always more than one way to do something. So, to the extent this is helpful to you, I would, recommend that you take a look at it and decide what you may want to use. The section on objections may be particularly helpful since I don't think we're covering objections as a separate component in the course, so that might be helpful. Okay, so today we're going to talk about direct examination. This is where you get to tell your client's story, and not only through the direct examination of the party that you're representing, but all of the witnesses that you choose to call. You're going to tell the story, the component parts of the story through those individual witnesses, through the direct examination. It is, needless to say, a very important component of your case. Cross-examination gets a lot of the attention. It's a lot more, dramatic, or could be, and we think of cross-examination probably as one of the more important parts of a trial, and no doubt that it is. But the direct examination is where you paint the picture that you want the jury to see. And the way you're painting that picture is through the words of the witness, right? So, you can't tell the story for them. You can give the jury a preview in the opening statement, but the actual evidence is going to come through the words of the witness. So it has to be crystal clear, coherent, compelling. It has to have easily followed components. That is the structure, right? It can't just be some, unending, or not unending, but continuum with just a bunch of open-ended questions: who, what, when, where, how, why, where everything sounds the same, right? You've got to structure it so that it has the maximum impact. And we're going to talk about the parts, the logical parts of every direct examination, and it'll make it easier for you to prepare your direct. Just as if you were painting a picture, right? You have a paintbrush and you have the strokes of the paintbrush, and the picture slowly, the painting slowly emerges, whether it's a portrait or a landscape, right? And you have a particular vision in mind as to what you want that to end up looking like. So that guides your strokes, right? And if the picture is not clear as you want it, you make adjustments. Well, that analogy, I think, is a good one to keep in mind when you're doing a direct examination. If the answers aren't coming out consistent with the picture you want the jury to see at the end, you have to make adjustments in your question. And so I'm going to talk about what the hurdles are to a jury getting a clear picture through the words of a witness. There are lots of impediments. There's objections from the other side, there's recesses, there's a lot of legal wrangling in between and bench conferences. So the jury doesn't get it as just a straight narrative, right? So you have to keep that in mind. You also have to keep in mind the audience, that captive audience, that is the jury, in determining how to present this information. But the main thing is that the story you want to tell, that's the picture you want to paint. And if the words aren't coming out so that the picture is crystal clear, you've got to go back in, or you have to keep at it, and you have to make adjustments in your questioning technique so that it is clear. And you do not move on until you have that clarity, especially if it's a material part of the witness's testimony. So that's kind of an overview of direct examination. It's critically important and is a real skill to eliciting the information in a manner that I just alluded to aspirationally as to what you're trying to do. So, again, some of the principles I'm going to talk about come from the art and science of trial advocacy. I will elaborate a lot on these principles and digress a little bit from some of the suggestions, but let's start with the first principle. It seems obvious, right? Ask clear and understandable questions. So, as you all know, the federal rules of evidence and the state rules, which mirror the federal rules, require that you ask open-ended, non-leading questions on direct examination. So what is a non-leading question? Well, the questions I rattled off earlier. Who, what, when, where, how, and why, right? So these are questions that do not suggest the answer. For example, what color was the traffic light when you approached the intersection? That's a non-leading question. A leading question, which you are not only permitted to do on cross, but you really do need to ask leading questions, would be, the light was red when you approached the intersection, wasn't it? Okay, that's a leading question, suggests the answer. Direct is verboten to ask leading questions generally on direct examination. Now, there are some well-recognized exceptions, including laying the foundation for an exhibit, even though I know some of the adjuncts admonished you when you may have lapsed into a little bit of leading and laying the foundation for exhibits. At least under the federal rules, it's my understanding, that's one of the areas where you are permitted to do some leading. Other examples is that if the witness is particularly frail or old or very young, you are permitted to lead. Transitional aspects of the testimony or anything else to develop the witness's testimony. That's the language from Rule 611C. Now, a couple of you said that, well, you know, you told us it's okay to lead in laying the foundation, to some extent, right? You take, again, everything with a grain of salt. Just because you may be able to do something, and there might be some dispute as to whether you could lead to lay a foundation. I'm going to ask Professor Cialino in a second about that. But just because you can do something doesn't mean you should do something. Generally speaking, when you're on direct, try not to lead. Two reasons for that. One is you're going to prompt an objection from opposing counsel, right? That's going to disrupt the flow and rhythm of your direct, so you don't want to do that. The other reason is that you might have a judge that doesn't like you to lead on direct, no matter what you're doing, even if it's within the boundaries of permissible leading under Rule 611. Right? So, with respect to the judge, and Judge Kovac, has in her section, I asked her, how do you feel about that? She said, I'm not going to let you lead on direct to lay a foundation or anything else. End of discussion. So that's the rule. Okay, what the federal rules or any exceptions might say, that's the rule, right? So just like if you're in an athletic contest and the referee is calling it close, calling, let's say in a football game, interference for the slightest little bit of impeding of the receiver, the ref is calling it close. So what do? You adjust your game, right? So the same thing with these notions of, you may be able to lead. And that's such a ticky-tack sort of small thing. It's not anything to be overly obsessed with. But I did want to address it since it was sort of conflicting advice. Now, Professor Cialino, let me ask you, since you focus a lot on evidence, what is your view on the permissibility of leading in connection with laying your foundation?
Yeah, I think it's fine because you can always do it to develop the witness's testimony. But, like you said, it's all a matter of how ticky-tack your opponent wants to get and the judge. So, I would try to move things along by, leading on foundations. But the minute you get cut off, say, well, I was just trying to move things along, Judge, I won't do it anymore. So here we go, and then just kind of, it's gonna take longer, and the jury's gonna look at you like, okay, here we go, we're wasting time. But that's the message I wanna send. All right, I'll do it like my opponent wants to do it.
We're going a long way. I was trying to go through the expressway.
It'll take longer, but then off we go.
Yeah, that's perfect. That's exactly, my views on it. Because, some of these foundations, as you've seen, there's a lot of moving parts to some of them, right? You gotta, bring in the magic language and all that. So, a few intermittent leading questions can really speed it along. But if you get dinged for it, no big deal, right? So, I don't want you to be overly conscious of leading, but generally, when you're on direct examination, just, go into the leading format. So if you can't remember anything else, who, what, when, where, why. Every question starts with one of those, right? And then you avoid leading questions. Okay, so the next thing is ask easily understood questions. Use regular language. Don't lapse into overly technical or lawyerly sounding words. Officer, what did you do when you exited the vehicle? You don't talk like that, do you? These people on the jury don't talk like that. Officer, what did you do when you got out of the car? There's nothing wrong with that. And actually, that connects with the jury much, much more vividly and in a more impactful way than when you start overly complicating the questions with technical language. So talk like people talk. The double direct. That's one technique that you can use to emphasize testimony. This goes back to something I said a little bit earlier, in that understanding how jurors get the information. They don't have any opportunity to interact with the witness, for one thing. And the witness's story doesn't come at them as an uninterrupted narrative, right? There are all these distractions that I've talked about. So those are barriers to the jury sort of understanding, well, what's important here, right? I've got all these distractions, disruptions. I'm getting this in little bits and pieces. What can you do to signal to the jury what is or is not important? One technique, now you gotta use this judiciously. You can't use it for every question or it'll dilute the impact, but the double direct. And that simply means using a part of the witness's last answer and incorporating it into your next question. So, for example, what did the man with the gun say to you? Right, that's the question. The witness says, hand me your wallet or I'll blow your head off. Your next question, using a double direct, would be, after he said, hand me your wallet or I'll blow your head off, what did you do? Right? Simple technique. I don't go doing that for every question, because you're going to get a cumulative objection, and it's going to start to sound, disingenuous. All right, so the next thing I want to talk about is structuring your direct examination testimony, and the use of a technique called blocking and headlining. Again, because the jury doesn't get this in an uninterrupted story, you have to tell them where you're going, right? And one of the ways to do that is to use blocking and headlining. And so What that consists of is kind of a statement of where you're bringing the story. You know, now that we know a little bit about you, Mr. Jones, I want to direct your attention to the events of July 20th, whatever the case may be, right? So you're telling the jury that, okay, we've learned about Mr. Jones and who he is, and he's married, and he's got 2 children. Maybe we should use the name Mr. Parker, right? So we know a little bit about him, and I'm gonna talk about that personalization block to begin with. But every witness's testimony consists of discrete blocks, right? And if that block starts with a headline, you're telling the jury, first of all, this is where I'm going next. This is where we just left, and this is where I'm going next. And you've got a discrete block of information within that block, and you ask the questions, the prodding questions that comprise that block, before you move on to the next block, right? So that structures your testimony. So the good thing, or the useful thing about that, is that every block is its own little universe, right? So if the block doesn't go very well, you get a chance to regroup and start over with the next block. Now you contrast that with the sort of continuum approach to asking direct, where you just go on and on and on with a list of questions with no demarcation between the areas that you're covering. Once that goes off the rails, and oftentimes it will on direct examination, it's kind of hard to get it back. But if you have blocks that are comprised of a specific universe of information that you tell the jury you're going to inquire about and ask those questions, and then you tell them, I'm finished and I'm moving to the next block, you get a do-over throughout every sequence of blocks during that direct testimony. Now, so let me just give you an example with blocks for any direct examination. You're typically going to have a personalization block. That is where you get the witness to tell the jury a little bit about themselves. You turn them into real live persons that the jury can connect with. I'm going to talk about personalization in a minute. And then the next block might be the staging block, where you set the scene for whatever it is they're going to testify. And this is for a lay or for an expert witness. If it's a lay witness or an expert witness on bad faith insurance claims procedures, you're going to set the scene by talking about generally how bad faith claims are processed and what the investigation techniques are and what the methodology is to determine whether the claim is submitted in bad faith or not. And then the next block would be the action block, right? And then you would probably have some sort of summary block or opinion or characterization block at the end. So the testimony consists of those structured components where the jury knows exactly what you're going to be talking about. You're going to have the prodding questions for each of those blocks, and it's going to tell you, it's going to structure your examination so that you know, okay, I'm done with my personalization block. I'm satisfied that this jury has a pretty good idea of who Mr. Parker is or who Jackie Fulbright is. I'm now ready to move on to the staging block. So Mr. Parker, now that the jury knows a little bit about who you are, I want to turn your attention to the events of Whitehall. Or now that we know that it's important to reward your clients or the assistance of your clients with lunches, etc., let's turn to the lunch that you had with Ms. Kim Anderson. That's sort of, that's setting the stage block and transitioning to the action block, which would be the actual lunch with Kim Anderson and what he had to drink, etc., right? So you're setting it all up. But you see the logical flow of that, and you see the benefit of having those discrete component parts so that, the witness no matter how much you prepare, sometimes it just doesn't go as well as you want it to. The witness gets nervous, or the witness doesn't remember, blah, 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 blah. So when you have these blocks, again, you get a chance to regroup, refocus the jury's attention on the next block. So I highly recommend that you give consideration to the blocking technique. All right. Now, this leading question prohibition, it's really a pain sometimes to deal with that, because theoretically, headlining and blocking might be construed to be leading, right? Under Rule 611, however, Federal Rule 611C, you're allowed to develop the witness's testimony. So if you have a headline where you're basically testifying as to where you're going, but if it's followed by a non-leading question, all you're doing is developing the testimony. And that would be a response to a leading objection. As long as you follow that headline with a non-leading question, I think you'll be okay. So don't let this prohibition against leading questions, again, stifle you too much, and to be not be overly concerned with that. Now, in terms of transitioning between blocks and how many blocks you're going to have, that's going to vary depending upon the kind of case it is, right? If it's a witness in a car accident, it may only be 3 or 4 blocks, right? Probably 4 blocks minimum. But if it's an expert witness testifying about a complicated matter, you may have a dozen or so blocks. So the number of blocks you have is going to be dictated by the nature of the witness's testimony. But as a general proposition, every witness's testimony will consist of that background or personalization block, the get to know you block, followed by maybe an experience or education or expertise block, especially if it's an expert, followed by a staging block, right, where you're setting things up, whether it's a scene of an accident, a diagram in front of the restaurant, so the jury has a clear understanding of the physical layout, or maybe it's a process, maybe it's the process of submitting expense reports. Generally, how do you submit your expense reports before you get to the specifics of how Mr. Parker entered his expenses for that particular lunch? And then that's going to be followed by the action block, right? That's the real, meat of the testimony. And then that may be followed by a summary block. It's going to vary depending upon the significance of the witness's testimony and what they're testifying about. But if you approach every witness with that overall framework in mind, it's easy to plug in, the questions that you're going to want to ask of that witness, because you know where you're going. You're not just starting with, okay, I've got this witness, I know they know X, Y, and Z, how do I structure it, right? So, all right. So, in terms of transitioning, I gave you an example earlier dealing with Mr. Parker. So now that we know why you take a client's personal assistants to lunch, let's turn to your lunch with Ms. Kim Anderson on the day of the accident. Where did you go to lunch? And you just take it from there with your open-ended questions. Why did you take Ms. Anderson to lunch? What did Ms. Anderson do to deserve your taking her out to lunch? Whatever questions you're going to ask within that block. All right. Let's talk about, more specifically, transitioning between blocks and the background or personalization block. See how we're doing on time? We're doing okay. So, now, just as it's true that every direct examination has these component parts that I've been talking about, or subparts, remember that the witness is a flesh and blood human being, right? So when you think about it from the jury's perspective, it's just as important for that jury to know who is testifying as it is to know what they're testifying about. So every direct examination, at least in my view, should start with some form of personalizing the witness, to reveal something about the witness's background. That's, the getting to know the witness part, and it makes the witness more accessible to the jurors. It gets the jurors understanding what makes that person tick, what motivates them. It depends on the witness, but things like their marital status, their professional activities, their children, any other significant part of their life that helps the jury to understand what kind of person they're listening to on direct. That gives the jury a way to identify with the witness too. Lots of times jurors make decisions based on credibility and trust, and sometimes the foundation for that trust is knowing what kind of person it is that is testifying, and a little bit about that person's background. Now, sometimes lawyers are resistant to that personalization part of the direct examination, and sometimes the court may, or the opposition may make a relevance objection, but it is very important for the witness to understand the human side to a witness. That's central to every case. So disclosure of the witness's background, builds that sort of common bond with the jurors and gives the testimony more practical meaning and ultimately more weight and credibility. So if you do get a legal objection to relevance, you could just respond to that by saying that you want the jury to understand this witness, to better be able to assess the witness's credibility, and be able to more appreciate the witness's testimony. Usually judges are going to allow some background questioning with all of the witnesses, and they'll allow even more substantial background questioning with the parties. But don't just bypass that opportunity. It's really important, because the decision of the jury is oftentimes based on intangibles, such as personal relationships and subjective impressions. So you have to put that witness in the most palatable light possible. And so spend some time personalizing the witness, because it will enhance the weight of their testimony. So, for example, let's take Mr. Parker again. Mr. Parker, before we get to the events surrounding the accident on July 20th, I want to ask you some questions about your personal background to help the jurors learn about you and to better understand your testimony. So tell us a little bit about yourself. Are you married? What's your wife's name? Do you have any children? Etc. So that would be an example of, headlining the personalization block before Mr. Parker. But it is very important. The next thing I wanted to talk about is incorporating pathos. Now, inevitably, you're going to have direct examinations that you want to minimize the occurrence of this, but they're not as dynamic as you would have liked them to be, or the jurors didn't seem particularly engaged. There might be any of a number of reasons for that. It could be that the witness was just a bad communicator. That happens sometimes. Could be that the testimony sounded rehearsed as much as you tried to not make it sound rehearsed. But sometimes it's because you didn't put the witness in a position to effectively communicate their story. So we've already talked about personalization as one way to get the witness to connect with the jury. But also getting the witness to open up and to develop empathy for that witness is situation, it's important that you ask what is up here, the feelings question. So, for example, if you're on direct examination with Jackie, you could ask him a question along the lines of, how did you feel, Jackie, when you were first told that you'd never be able to play football again? Right? That's likely to elicit a very emotional, passionate response that will resonate with the jury, right? And create the empathy and the requisite pathos that you want to create so that the jury is ready to rule for your client at the end of the case. Jackie, what went through your mind when you were told that you could suffer these seizures at any time, any place, without any notice? Can you imagine the response there? Or, Jackie, what did you think when you were told you'd never be able to drive a car until you were seizure-free? And that you might not ever be seizure-free. So that's an example of the so-called feelings questions that I have up here. So remember to incorporate that into your direct as obviously appropriate. You're not going to ask necessarily a police officer who's just, taking a report, a feelings question. Okay? But you get the idea. For a party witness, there's usually going to be some opportunity to ask that feelings question. Okay, now setting the stage. Just like all of us, jurors want to know the context in which the events took place. So, part of the context is the environment, the conditions, the process that was involved. And so, setting the stage is an important part of the process, right? So you're going to go from the general to the specific. I gave you an example earlier about expense reports. What goes into the process of preparing an expense report at your company, and a series of questions detailing that process. Now you move to the specific. Okay, let's turn to the expense report on July 20th. Did you, make this entry? When did you make this entry? Et cetera. Was it consistent with the requirements that you just articulated for filling out expense reports? I'm just giving you an example. All right, so setting the stage is important for a number of reasons. Another example would be the traffic lanes in front of the restaurant, right? Start from the general, setting the stage, before you go to the specific in the action sequence. One of the reasons for that is that you don't want to distract the jurors with filling in that information, right? If you go straight to the action sequence, okay, Jackie, you were driving down whatever street it is, and you, what happened next? Well, I switched lanes. Well, which lane were you in? Were you in the far left lane and you switched to the middle lane, blah, 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 as opposed to getting Jackie to describe the 3 lanes and the use of a lane closest to the sidewalk for, the valet parking. And you've already set that up. So when you get to the action sequence, I move from this lane to that lane. You don't have to fill it in with all of that descriptive information, right? Or if it's with expense reports, we go back to that example. If he's talking about what he did for that expense report, you don't have all of this. Well, let's go back. What is the normal way to do the expense reports, and when are you supposed to fill it out, and when are you supposed to submit the receipts? By injecting all that clutter, you're disrupting the flow of the testimony, and you're diluting the impact of the action sequence for that particular component of the testimony, which is what you want the jury to focus on. So setting the stage is crucial, right? So you see how this is developing in terms of the blocks. The personalization. I know what makes this witness tick. Okay, now we're going to get to setting the stage of whatever it is the witness is testifying about. I got a general understanding of the context of what it is he did. Now we get to the action. What did you do? So everything follows logically, and you're ready to go, and the witness is ready to give the story, the jury is ready to receive it, knowing full well, you know, what they're hearing, why they're hearing it at this juncture, in the context in which they're hearing the information. So proper staging protects against those kinds of distractions of having to go back and fill in the information, you know, to describe a process or a scene while you're getting the witness to also talk about the action sequence itself, which is the most important part of the whole story, right? Why that witness is testifying, why they're here. So if you set it up properly, you know, the action sequence is like the last act of a play, right? In the preceding acts, you learn who the characters were, you know, what motivates them, what their relevant histories are, and then you lift the curtain for the final act, right? So the same thing with these various blocks, including the staging block. It sets it all up for maximum impact. All right. So let's see what we have next up here. Fully develop the action sequence. One technique for developing the action sequence and highlighting what's important is something called freezing the action on important points, right? We've already talked about the use of the double direct, but the use of the double direct, you can't use it for every question, and you've got to vary it up. So freezing the action on a critical part of the witness's testimony can be very, very effective. So, for example, and I'm trying to think of an example from this case. If, let's say Parker is testifying, well, let's take Kim Anderson, just to use a different witness. She's at the lunch with Parker, and of course, his state of inebriation is a critical part of the case. So she testifies he had 2 martinis at lunch. So you would freeze the action, or arguably there'd be an opportunity to freeze the action. Now, Ms. Anderson, I want to stop you right there. You said he had 2 martinis at lunch. Is there any doubt in your mind that he actually had 2 martinis? Yeah. How do you know it was 2 martinis? And that would be another technique, which is called parking on the testimony. But in terms of freezing a testimony, that's just saying, stop the cameras, everybody. I want the jury to know that this is important. So, Ms. Parker, I want to stop you right there. You said he had 2 martinis at this lunch? Good. So, you know, that's another technique, along with the double direct, for developing not only the action sequence, but the direct examination testimony overall. Also, filling in the gaps in the story. I'm telling you, I don't care how well you prepare your witnesses, and when you all do your direct examination, when you will not have had a chance to work with the witness, it's surely going to happen. You're going to ask the witness a question. You know, you might ask him a question. Let's take Mr. Parker again. What did you do when you got into your car after the lunch? Oh, well, you know, I got in my car, I checked my mirrors, I turned on the radio, pulled out into the lane, and wham, before I knew it, I was hit by Jackie. Well, you don't want that sort of, you know, general statement of all those important facts to just get lost in this, you know, clumped together mass of information. So the the witness will start to just, he or she will just say, rattle off a whole bunch of things. And it's like, okay, we talked about this in prep. So what you might want to do, or even if, you know, he says it, and, you know, it's like, well, we didn't practice it this way, but he said it. or at parts of the testimony, they will rattle off information. You gotta go back in and fill in the gaps. You know, so Mr. Parker, let's back up a little bit. Let's talk about what you first did when you got into your car. What was the very first thing you did? You know, well, I turned on the radio, I turned on the air conditioning, or the radio was already on. What was the next thing you did? Well, I checked my rear view mirror. Okay, you checked your rear view mirror, and what did you see when you checked your rear view mirror? Okay, what was the next thing you did? I checked my side view mirror, and what did you notice when you checked your side view mirror? Okay, now what was the very next thing you did? Well, I looked to see if there was any oncoming traffic. Was there any oncoming traffic when you visually checked? No, there wasn't. And so what was the next thing you did? I pulled out into, slowly, into the lane of oncoming traffic. You know, and so you're filling in the gaps. But don't let a witness rattle off important, you know, a whole bunch of important information in one sort of, you know, clumped together statement, narrative statement. It's your task as a direct examiner to break that up and to make sure, especially those parts that are very important, you know, get fleshed out individually. So, you know, let's back up a little bit. I want to first talk about the very first thing you did when you got into the car, just using that example, right? So that's filling in the gaps. We talked about using a double direct, and I've given you a sort of a little illustration of parking on important testimony. That's yet another technique that you can use. And in parking, you're going to ask closed-ended questions. You're going to keep them limited in time and scope, and you're going to focus on very specific details of the particular event. You know, so you're going to hang around, and you're doing that because you want to emphasize it, right? So you got to be patient, and you got to be willing to go through, you know, that series of questions, which can seem very tedious, but it can be very important. There are too many opportunities in this case file for parking that I can think of off the top of my head, but you know, I do think there's opportunity in the example I gave you with what Parker did in, you know, before he pulled out into the lane of traffic, and that, you know, culminating with Jackie running into him. Now, you know, you did not hear the motorcycle? Did you see it out of the corner of your eye? Did you hear it coming? You know, how much time between, you know, you realized you were being hit and the impact? Well, it was almost instantaneous. It was a flash, right? He could say, boom, he hit me out of nowhere, and you can move on. But if you park on that highlights the notion that Jackie was going at an excessive rate of speed, given his prior testimony, Mr. Parker's, that he slowly pulled out into the lane of traffic, and it was clear, right? So if you park on it in tedious detail, it's another way to emphasize that important part of the testimony. Now, again, the double direct, the freezing, the parking, you're not going to do that for every aspect of it. So use it judiciously where it really counts. Okay? I'm just moving a little bit faster than I'd probably like to because of time. So, okay, disclosing material weaknesses. Disclosure is going to enhance your credibility. You inevitably will have some facts that are, you know, disputed, right? And some of those facts may not, you know, be favorable to your case. And so you have to deal with them and disclose them during a direct examination. We talked about disclosing weaknesses potentially in opening statement, not disclosing too much, but disclosing material weaknesses, weaknesses that are outcome determinative, and very importantly, from a practical standpoint, weaknesses you know the other side is going to bring up. So if you don't think, you're not sure if the other side is going to bring it up, don't go disclosing the weakness, right? But you have a pretty good idea through discovery and the kind of questions that they're asking of your witnesses as to what they intend to pounce on in terms of the weaknesses of your case. And there's some rather obvious weaknesses on each side of the case here. So only material witnesses. When to make the disclosure on direct examination? Well, the tenets of primacy and recency dictate that you don't do it at the beginning, right? You do it at the beginning, you've already watered down your case. You do it at the end, that's the last thing that they remember, and that's not favorable to you. So usually it's going to be packaged somewhere in the middle of the testimony, right? How to make the disclosure on direct examination. It's less important how you make it than it is that you make the disclosure if it's a material weakness. Two ways listed here. One is the conventional disclosure. For example, let's take Jackie, moving around the truck, right? So, Mr. Fulbright, or Jackie, you testified that you decided to go around this slow-moving truck. Why did you do that? Right, that's a conventional way. And he said, well, for two reasons. First of all, the diesel fumes from the truck on a hot day were making it very difficult for me to see, and I thought that created danger. Secondly, this truck was moving so slowly, the impatience of the cars behind me being on a motorcycle and thus particularly vulnerable to a rear-end collision, made it even more unsafe for me to stay put behind this slow-moving truck. And that's why I made the decision. That would be the conventional disclosure. Another way to do it is the challenge question. So Jackie, you said that you decided to go around this truck. Wouldn't it have been better just stay in your lane? No, it wouldn't have been for the reasons that I just articulated. It doesn't matter which approach you use. It's just, these are two different ways to get at it. All right, adopt a winning attitude. Your structure has to be important. Questions have to be framed properly. For maximum impact, you've got to use the techniques we've talked about. But don't forget about your demeanor. The jurors are going to have their eyes on you from the moment you step up and start questioning the witness, right? So your temperament, your style in handling the witness, where you stand, how you portray yourself as a truth giver, and just the way that you move around that courtroom and the way you ask the questions is very important. So, a couple of things here. Don't rely on notes, right? Notes, first of all, scripts never work in trial. The witness may, rattle off 3 or 4 things that eat up your next 3 questions, or they may say something or omit something that's critical to your next 3 questions. So, you don't get to stay with the script. Or the witness may say something that surprises you, right? And if you're too bound by notes, first of all, the answers are going to come across as canned, right? So that's going to undercut your credibility. And it's going to be both a straitjacket and a magnet. It's going to be a magnet because your eyes are going to be inexorably drawn to the notes. If you got them, you're going to read them, right? And it acts as a straitjacket because you're bound by what's on that paper and those notes. So you're not listening to the answers. The next question you ask will be dictated by the answer you hear, right? So if you have your scripted questions and you're looking at your next 2 or 3 questions, you're telling the jury, I'm not interested in the answers, right? Because I'm looking at the questions and I'm not even thinking about the eye contact with the juror and listening to the answers and naturally responding to the answers. Or it's telling them that, the answers are all canned anyway, so this is just one big charade. I don't have to listen to them. So you don't want notes in front of you scripted out with question by question. Or at least I think it's more of a hindrance than a help. We are getting close to finishing, but I do want to emphasize that is very, very important. Listening to the answers will tell you where to go. Sometimes a witness will give you an answer using verbiage that is particularly impactful, in which case you want to park on that verbiage, right? You want to get a little bit more juice out of it. Or it might be particularly weak, and you need to clear it up. So if you're just looking at the next question, you're going to miss those opportunities to paint that clear picture that we've been talking about. Listening to the answers, the most important part of direct examination, without question. Don't echo the answer, you're all gonna do it, you're gonna say, okay, or you might even repeat the last part of the witness's answer. Don't do that, that's just filling dead time. That's, usually a little sort of nervous tick that we all have because we don't like silence, so we say, okay. You can rid yourself of that habit, the adjuncts will probably tell you when you're doing it, you won't even realize you're doing it. But don't say, okay. Staying close to the jury box, we've already talked about that. By standing in the jury box, you force the witness to look towards the jury when they're giving the answers, and it forces the witness to speak loudly enough for the jury to hear the answers. Plus, it allows you to connect with the jury just by that physical proximity, standing next to the jury box. So, sorry about the rushing at the end, but.
So on Monday, are we just picking one witness? How are we
No,
comparing?
for the assignment, each side, if you're on the plaintiff side, you're gonna do a direct Jackie Fulbright. If you're on the defense side, you're gonna do a direct your client, Andrew Parker.
Okay.
Okay?